Thank you everyone for coming out again, and I say coming out facetiously, but thanks again for all joining us this evening. Doug and I are pretty excited to get through this program, and we're really excited for the program tonight. I think we've got some dynamic speakers, and we're going to start off with Judge Fenstermacher, who's going to talk a little bit about how do you prepare your case for trial. Judge Fenstermacher, thank you for joining us tonight.
Well, I'm thrilled to be here. I'm not so sure that I'm going to be educating all of you very much because I know most of you are so competent and probably know a lot of what I'm going to tell you. But I have presided over a lot of these cases, both in the criminal arena and in probate. So let me start out by describing what the Elder Abuse and Dependent Adult Civil Protection Act is. This was enacted and set forth in Welfare and Institutions Code sections 15600 through 15675. Now I am looking at a memo that I had prepared, and it's about 5 pages, and I'm hoping that you all will have a copy of this eventually. Obviously, if we were live, you would have it. So if you miss a lot of it, or if you're tired like I am and wishing it were Friday and you don't feel like taking notes, you will have a copy of this memo eventually. So an elder is any person residing in California who is 65 years of age or older. And I will dare say that I qualify as a potential victim. But anyway, so it is a cause of action as well as a remedy. Now, there is a 4-year statute of limitation on this cause of action. And that's important because the 4-year statute of limitation runs from the date of discovery of the elder abuse or through the exercise of reasonable diligence when it should have been discovered. Now, the reason that's significant is that sometimes there is a statute of limitations issue that can appear on the face of the pleading, and the court has the discretion to sua sponte or on the request of either party bifurcate out that issue and have an evidentiary hearing on the statute of limitations. So that is something for people to consider, particularly when they're defending one of these. So financial elder abuse occurs when a person or entity assists in or does any of the following: takes, secretes, appropriates, obtains, or retains real or personal property of an elder for a wrongful use or with intent to defraud, or both. And this is set out in Welfare and Institutions Code section 15610.30, subdivisions A 1 through 2. Now, in preparing for the presentation of an elder abuse case, I would suggest that you review the California civil jury instructions. And those are CASI 3100 through 3107. The benefit of that is a jury instruction actually helps you outline your case. And that would be both at the pleading stage as well as the trial stage, because there are elements that you have to prove, and the jury instruction sets those out very clearly. So even if you're not going to seek a jury trial, it makes sense to take a look at the jury instruction, because it really does organize the presentation, both in the pleading and at the time of trial. So this may occur when a person or entity does the things that I have just described: takes, secretes, appropriates, obtains, or retains real or personal property. And that can be done by undue influence, as defined by Welfare and Institutions Code, section 15610.70. Now, here's an interesting thing. There are 3 different code sections that define elder abuse, and all of them are fundamentally the same. You can find it in 156 610.70, and this is elder abuse by undue influence. This is also set forth in Probate Code Section 86, which defines undue influence. Parenthetically, it defines it exactly as it's defined in Welfare and Institutions Code Section 15610.70. So taking means the deprivation of any property right, whether prospective or actual. And in this memo, I do have some case citations, which I won't bother you with now because my expectation is that you'll have the memo and you'll have the case citations. The abuse may be done, for example, by means of an agreement, or as we often see, a donative transfer or a testamentary bequest. Again, this is all set forth in Welfare and Institutions Code Section 15310.30, Subdivision C. So what we tend to see is the elder abuse by undue influence. And that's defined in Welfare and Institutions Code Section 15610.70, as well as those other code sections that I referenced. So in determining whether the abuse is a result produced through means of undue influence, all of the following shall be considered: the vulnerability of the victim, and evidence of vulnerability may include, but is not limited to, incapacity, illness, disability, injury, age, education, impaired cognitive function. I think that's what we mostly see in probate court, emotional distress, isolation, or dependency. And that's whether the influencer knew or should have known of the alleged victim's vulnerability. The influencer's apparent authority, evidence of such may include, but is not limited to, status as a fiduciary, a family member, a care provider, a health care professional, a legal professional, a spiritual advisor, an expert, a romantic partner. And these actions or tactics used by the influencer, evidence of such action or tactics used may include, but not be limited to, the following: controlling necessities of life, medication, the victim's interaction with others, including family members, access to information, use of affection, intimidation, or coercion, initiation of changes in personal property or property rights, and done in haste, with haste and secrecy. And the equity of the result. Evidence of the equity of the result may include, but is not limited to, the economic consequence to the victim, any divergence from the victim's prior intent or course of conduct dealing with the relationships, the value of the property, or the value of any services or consideration received, and evidence of an inequitable result. However, here's the important thing that we see a lot, and that is that evidence of an inequitable result without something more is not sufficient to prove undue influence. Now, there's a case that I just came across, and we all assume, of course, that this has to be proved by a preponderance of the evidence, which is always the default position in civil and probate cases, unless a code section says something different. However, I came across just recently a case called Doolittle versus Exchange Bank. This is a 2015 case. This citation I am going to give to you, it's not in my memo. This is 241 Cal. 4th 529. And in that case, the court indicated that undue influence must be proven by clear and convincing evidence when when it's necessary to protect an important right. So there is some issue about what the actual burden of proof is. And if you are going to present one of these cases, it makes sense for you to do research on the burden of proof and what the standard is, and educate us judges in terms of why a particular burden of proof you believe is appropriate. So, assessing capacity. Testamentary capacity is defined in Probate Code section 6100.5. That's sort of a lower requirement as opposed to contractual capacity or the capacity to create a trust. So 6100.5 is really generally applicable to wills, where Probate Code sections 810 through 812 usually is a contractual capacity or a capacity to prepare and enter into a trust. So the challenger to the testamentary document has the burden to prove lack of capacity. Now, there are two leading cases on assessing capacity, and I do have them in my memo that you will receive, but I'll briefly mention them. One is Anderson v. Hunt, which is 2011, 196 Cal. 4th, 722, and Lentz v. Lentz, and that's Lintz, and that's 2014, 222 Cal. 4th, 1346. Now, these cases stand for the recent shift in decisional authority, which states that capacity should be measured on a sliding scale, depending on the complexity of the amendment or change to the estate plan, which I think is interesting because it, well, and also troublesome because it creates a very gray area. But generally, what they say is that the more complex the change, the higher the capacity standard that should be applied. So the more complex the change is, then you're going to be looking at that contractual capacity standard under Probate Code sections 810 through 812. Something less complex, then you have a lower capacity standard, and that's the Probate Code section 6100.5. So another point that I wanted to make about these cases is we tend in probate to see petitions that kind of are what I call garden variety, in that they allege elder abuse, but they also allege a constructive trust and or petition for instructions. They're sort of combined with other types of causes of action. So a standalone elder abuse case can result in a jury trial if a party requires or requests one. But when it's combined with legal as well as equitable remedies, then what can happen, either sua sponte by the court or by one of the parties, a request to bifurcate out those claims in equity and hear those first, and then if the remaining elder abuse claim stands, then the jury trial would go forward. Okay, so let's talk about the available remedies for financial elder abuse. We've got general damages, and that's, of course, the recovery of what was lost. And that can be actual loss or depreciation plus interest, profits made plus interest, lost profits that would have accrued, or general damages against a trustee as set forth in Probate Code section 16440, or against a conservator as set forth in Probate Code section 2401.3. Now, Probate Code section 859, that includes the double damages. So that's if you're including 850 petition with this, what I call the garden variety elder abuse claim. If the court finds that a person has in bad faith wrongfully taken, concealed, or disposed of property, or has done so by the use of undue influence, in bad faith or through the commission of elder abuse, financial abuse, the person shall be liable for twice the value of the property recovered. So I recently had a case where part of what is included in the action, and this is what we see regularly, is a constructive trust. So the son convinced mother to transfer title to her home to him. And ultimately, after the trial, it was determined that he did commit financial elder abuse. And the son argued that, well, look, the house is still here, so I'm just going to transfer it back, so there are no damages. Well, in reality, there are damages, and that those damages are computed by determining the value of the house and doubling it. So that was most disappointing to him. So, all right, so except as otherwise required by the law, the person may, in the court's discretion, also be liable for reasonable attorney's fees and costs. The remedies in this section shall provide, in addition to any other remedies available, punitive damages. Now, you've got a different burden of proof if you're claiming punitive damages based on fraud, oppression, or malice. That burden of proof is by clear and convincing evidence. So if you're seeking punitive damages, then you have the burden of proving by clear and convincing evidence that the respondent is guilty of fraud, oppression, or malice. Also, you can seek treble damages for unfair or deceptive practices pursuant to Civil Code Section 3345. Now, when a trier of fact is authorized by statute to impose a fine or other civil penalty, the purpose of which is to punish and deter, that's what punitive damages do, the trier of fact may impose a fine or other remedy up to 3 times greater than it would be in the absence of that finding if the following exists: whether the defendant knew or should have known that his or her conduct was directed to one or more senior citizens, or 2, whether the defendant's conduct caused one or more senior citizens to suffer loss, encumbrance of a primary residence, substantial loss of property, interference with retirement, or for personal or family care and maintenance, or substantial loss of payments received under a pension plan or retirement plan, or any other government benefits. And whether one or more senior citizens are substantially more vulnerable than other members of the public, so the defendant's conduct because of age, poor health or infirmity, impaired understanding, restricted mobility or disability, and actually suffering substantial physical, emotional, or economic damage resulting from the defendant's conduct. These are other damages that can be sought pursuant to the Civil Code, and that is Civil Code Section 3345. And we're looking at subsections B, 1 through 3. Now, attorney's fees, always an issue near and dear to all of our hearts. And that is set forth in Welfare and Institutions Code Section 15657.5. If a petitioner proves financial abuse by a preponderance of the evidence, in addition to all other remedies, the court must award the plaintiff reasonable attorney's fees and costs. And the costs includes, but are not limited to, reasonable fees for services of a conservator, if any, devoted to the litigation of the claim brought under the elder abuse statute pursuant to Welfare and Institutions Code. Now, here's another interesting thing that I just learned. I did not know about this. You can actually recover pain and suffering pursuant to Welfare and Institutions Code Section 15657.5, Subdivision B. on behalf of the elder. So under Civil Code Section 377.34, in actions or proceedings by a decedent's personal representative or successor in interest on the decedent's cause of action, damages are limited to loss or damages that the decedent sustained or incurred before death. And that includes any kind of damages, which also includes punitive damages, but not damages for pain or suffering. But under Welfare and Institutions Code, Section 15657.6, once financial abuse is established and is proven by clear and convincing evidence that the defendant or respondent had been guilty of fraud, oppression, or malice, the limitation of damages imposed by Codicil Procedure Section 377.34 do not apply. Thus, even if the victim is deceased, if financial elder abuse is established, as I said, by clear and convincing evidence, pain and suffering damages could also be awarded. That's something that's unusual, and I have yet to see that actually in a petition. So the perpetrator is deemed to have predeceased the victim pursuant to Probate Code Section 259. That means they can't inherit in the estate. A person shall be deemed to have predeceased a decedent to the extent of the property damages or other actions awarded if it's proven by clear and convincing evidence that the person is liable for physical abuse, neglect, or financial abuse. Victim was an elder. The person is found to have acted in bad faith. The person is found to have been reckless, oppressive, fraudulent, or malicious in the commission of any of these acts upon the decedent. And the decedent at the time of those acts occurred and thereafter until the time of his or her death has been found to have been substantially unable to manage his or her financial resources or to resist the fraud or undue influence. So any person found liable under these sections, and this is Probate Code Section 259, subsections A, 1 through 4, any person found liable shall not receive any property, damages, or costs that are awarded to the decedent's estate in an action described herein, and they cannot inherit under the will or trust or the laws of intestate succession. Now, we often see these petitions including an 850 petition. So an 850 petition with a financial abuse action is sort of that, what I call that garden variety, general garden variety petition. And a claim pursuant to Probate Code Section 850 is used to recover the real or personal property held by another, belonging to a trust or conservatee. The claim must be evaluated in the context of related civil claims. That's set forth in Probate Code Section 854.856.5. Now, this makes me circle back to what I had said about when you have all these different claims set forth in a single petition. It makes sense if you have an elder abuse claim that is entitled to a jury trial to bifurcate out the other claims or remedies and have the court hear that first. Then again, if there's anything remaining to the initial claims, you could then move forward with a jury trial on the elder abuse claim. So rescission is another remedy, and that's rescission for undue influence is set forth in Civil Code Section 1689, and this is in subsections B1, 1575, and 1566. And this is rescission for fraud. Consider seeking a rescission in the sale of a real property if the note has not been transferred and there's no bona fide purchaser in the cases involving fraud. So, you have the situation where the title has been transferred to the undue influencer or the elder abuser. Then they try to sell the property. Rescission is a remedy. So also, of course, we all know about constructive trust. And the constructive trust is an equitable remedy. And typically that's included in a petition for elder abuse. Constructive trust can be imposed to prevent a party in possession of property from being unduly and unjustly enriched. And one who wrongfully detains a thing, and this is set forth in Civil Code section 2223, or gains a thing by fraud, mistake, undue influence, violation of a trust or wrongful act, this is Civil Code section 2224, is an involuntary trustee of the thing gained. So they then can have a constructive trust imposed upon them for the benefit of the person who would otherwise have had it. So under these statutes, the only conditions necessary for the imposition of a constructive trust are the existence of a race, the right of the plaintiff to that race, and some wrongful acquisition or detention of it by a party who's not entitled to it. And that's often what we see included in these petitions for elder abuse. Again, that's a remedy. It's an equitable remedy. The other thing that I often suggest to people is that if a parcel of real property is the subject, among other things, of the elder abuse petition, once you file that petition, file a lis pendens, or I should say record a lis pendens against the property, which will tie it up. So I doubt that I told you anything you don't already know. But if I can leave you with one pearl of wisdom, that would be definitely review the California civil jury instructions on elder abuse, because I think it really helps organize not just your presentation at trial, but actually at the pleading stage. Then the other thing with regard to the pleading stage is that don't plead conclusory allegations. Set forth facts, alleged facts, but set forth facts that are more than just a conclusion, that's a recitation of the elements of elder abuse. Because if you don't have facts alleged, then it makes your petition vulnerable to demur. So you'll always get one shot of leave to amend on a demur, but nevertheless, be prepared to allege actual facts. And I think that's all I can give to you, and probably didn't tell you anything you don't already know.
Thank you, Judge Fenstermacher. We really appreciate your time this evening. We do have a few questions, but I think those would be better suited to send to you after tonight's program. So you'll get some stuff from us.
Well, I look forward to it.
Great. Well, thank you again. We appreciate you being here this evening. And our next presenter is Judge Virginia George, who is the other judge in our probate department. So Judge George, please join us.
Okay, hello to everybody. Let's see, good evening. Thanks for coming in tonight. It's nice to be here. I'm happy to help if I can. I haven't been a judge nearly as long as Judge Fenstermacher, so I don't have the trial from the judicial side experience that she has. However, since I've been here as a judge, there have been a number of hearings that have taken place. No jury trials for because of the COVID issues, but I have done a number of court trials, most of which had nuances or direct issues relating to elder abuse, mostly elder financial abuse, but one actually did have an elder physical abuse issue. But granted, most of the time that we see these cases go to trial, it's usually a financial abuse component. Before I begin tonight, I wanted to note that we are not able yet to hear jury trials. As you probably all know, we recently just opened last week after the second COVID closure. We are hearing court trials. We're slowly getting back into the real-time world. So right now I'm hearing court trials in person. I think Judge Fenstermacher is still doing Zoom to some extent on the court trials. As far as jury trials, I know a couple of folks have already asked about that, because these can be jury trials. Elder abuse can be jury trials. As far as jury trials from here on out, we're still in a holding pattern. As you can imagine, there's an extreme backlog of cases, criminal cases, and of course they get priority. And for the foreseeable future right now, I don't have a date when we will be getting jurors. We remain hopeful, but right now, we do not have jury trial capacity yet. We will, but we just don't yet. So that's sort of the state where we're at currently, but this is going to be subject to change as we go through and more of the criminal cases go through the system and get tried. As I mentioned a moment ago, they obviously have priority. So my piece tonight is going to be mostly having the practical aspects of what's going on as far as a trial is concerned. And I'm going to be bringing up some recent issues that seem to be gaining some traction and momentum in cases, mostly elder financial abuse cases or undue influence cases, where you have an elder party or witness, but mostly an elder party that is 70 years or older. I've been noticing anecdotally, at least in my court, there have been a number of trial preference motions because of an elder party, and I've been hearing them, and most of the time, anecdotally, I've been granting them because they are put together correctly with the proper declaration and the proper proof has been presented. Also, sort of to zone in on what I'm going to be doing during my speech tonight, I'm going to talk more about the practical issues arising during the trials that I've seen so far, and some common mistakes that have been being made, mostly with evidence issues. I have seen some improvement. I've had people come back after their first trial or so, and I've noted that they've improved. So it's good to see. And as an aside, I've seen a lot of my former evidence students in front of me for hearings and trials, and I'm pleased to say, don't get too big of heads now out there, you guys, but you guys are doing very well. So I'm very proud of all of my evidence students who are now practicing in the probate departments. So let me start first with the trial preference statute. As you all know, that's Code of Civil Procedure, section 36(a). That section allows a party to a civil action who is over 70 years of age to petition the court for trial preference. Now, there are two findings the court will need to make, and the language used in making those findings are: the court shall grant the petition if the court makes both of the following findings. The first finding is the elder party has a substantial interest in the action as a whole. That's number one. And number two, the health of that party is such that a preference is necessary to prevent prejudicing the party's interest in the litigation. Now, the term substantial interest is still kind of a moving target. It has, as far as I can tell, it has not yet been developed or defined too terribly succinctly by case law. But that's, of course, on to the judge's discretion on the substantial interest in the action. Most of the cases that I've gotten, again, anecdotally, are elders that are parties to the action. But again, note the language of the statute. A party to the civil action who is over 70 years of age. But there is also some dicta that may allow, and I haven't fleshed this out yet. I will be giving out a handout to the 36A, but there may be some dicta that allows a witness some priority, but it's a little dicey right now. So right now I'm just going to stick with parties. Okay, so what's the procedure and what's the standard on a trial preference request? Okay, so the Codicil Procedure 36C, paren C, states the following. Unless a court orders otherwise, quote, a party may file and serve a notice, motion, or ex parte application for preference. I've had both. The motion should include a declaration by the moving party and that all essential parties must be served or have appeared on the case. A party who reaches 70 years of age during the pendency of the action, this is also an interesting part of the statute. Let's say you have a party who's 69 and during the pendency of the action, he or she becomes 70. So during the pendency of the action, if a party reaches 70, that party may at any time during the pendency of the action file and serve a motion for preference. So then you're kind of covered if you've got an elder who's 65 or older that's not 70 yet, but somewhere along the practice, somewhere along the trajectory of the litigation, he or she turns 70, then you can still bring this motion. 36D, Codicil Procedure Section 36D, states that the court has discretion to grant a motion for preference that is accompanied by clear and convincing medical records that concludes that one of the parties suffers from an illness or condition that raises substantial medical doubt that the party will survive beyond 6 months, and that satisfies the court that the interest of justice would be served by granting such preference. These again get very case specific, but again, this section allows the proponent to bring forth medical records that support that, that proposition. And that would be the party suffers from an illness or condition that raises substantial medical doubt that the party will survive beyond 6 months. And that satisfies the court that the interest of justice will be served by granting the preference. Again, note that the burden of proof here is clear and convincing evidence. Now, this is an interesting part of CCP 36. It's 36.5 that I'm not sure if people are aware of, but when you read the statute, it's an interesting piece. CCP section 36.5 allows an attorney to sign a declaration for the party seeking preference based on the attorney's information and belief as to the medical diagnosis and the prognosis of any party. However, that declaration cannot be admissible for any other purpose other than to support the motion per preference pursuant to Code of Civil Procedure section 36A. So if the party believes, if the proponent believes that he, she, the attorney needs to personally submit a declaration, it appears that if they have information and belief that as to the medical diagnosis and prognosis of a party, the court may consider that. Again, it can only be used for that specific one-time purpose and not for anything else. So please bear that in mind. One other thing under California Rules of Court, I've noted, and for the record, this is in the memo that you'll be getting. It's California Rule of Court 3.727 paren 12. 3.727 paren 12. Attorneys may raise the issue of preference at any case management conference. Now, currently in our probate division, we don't have those, but again, this is a civil remedy. So, you know, if you have civil cases with elder abuse claims or with elders, frankly, you can raise it at your CMC. So there's that piece. Now, one other piece of this is the continuance of the date that gets set. So let's start with the date that gets set and then move out from there, because this is also not an uncommon issue. So if the motion is granted, let's say you file your motion for preference, if the motion is granted pursuant to CCP section 36F, the court shall, again, shall, quote, set the matter for trial not more than 120 days from that date, and there shall be no continuance beyond 120 days from the granting of the motion for preference, except for physical disability of a party or a party's attorney, or upon showing of good cause stated in the record. So you get your 120 days. Let's say you're successful in your motion, get your 120 day or so setting, 4 months or less away. But somewhere along the way, something comes up and someone has to ask for continuance. Now, if there's a physical disability of a party or a party's attorney and good cause is shown on the record, the court may consider the continuance, but there's a caveat to that too. And that's the next sentence. Any continuance shall be for no more than 15 days and no more than one continuance for physical disability may be granted to any one party. So that's out there, but it's a very limited exception to that rule. I would suggest, again, because these seem to be more popular, I would suggest that everybody familiarize yourself with 36A and the sections I've cited. And again, this is in the memo that I'll send out through Sam and Ann and Doug. Please make sure you familiarize yourself with that, because sometimes, this has come up as well, parties aren't as thorough in following the code requirements, and as such, their motions will and have been denied. And these are extremely vulnerable people, as we all know, especially if they get to a certain point in their life when they're 6 months or less potentially away from passing away. You want to make sure you get it right if you're going to ask for them. So just please make sure you take a look at the section and follow it to the letter. And remember, it also can be a notice motion or it can be an ex parte. So there's that. I want to shift gear for just a second here, just hit on a couple of common mistakes or fallacies that I'm seeing even after the case gets all the way down to being in a trial position or hearing. And that is folks that are representing the elder. Let's say your elder is alive and is doing fairly well considering the circumstances. Sometimes I've seen counsel for their clients, for their elderly clients, not, how can I say this, not go to bat as strongly as I think they can, because they think that sometimes their clients are more competent or more sophisticated. Sometimes they just don't really push the envelope as hard as they could. Often, as we all know, and I know I'm preaching to the choir, but often, as we all know, the proudest, most sophisticated, well-educated elder falls prey to an unscrupulous victimizer because they are self-reliant, or they are in denial about their limitations, or they just are proud, or embarrassed. That's a real life issue here. And they seem to underestimate or undercut what's gone on with them. So this could be in the beginning as well, when you're getting your case prepared to file, or as you're going through. But it also it can be an evanescent time for this victim, because they don't necessarily they don't want to admit that they've been hurt. They don't want to admit they've been bamboozled. They're very proud, and sometimes the practitioners kind of don't really dig into it as much as they should. This comes a lot when you have a professional who's an elder, a doctor, a retired doctor, retired lawyer, or just someone who's used to being in charge, a teacher, whoever. A lot of times they're very reticent to come forward. I would encourage you, and I know I'm preaching to the choir. I'd encourage you to please continue to have those conversations with your client to make sure you're getting everything from them, because oftentimes it really is like going through an onion, getting down through the layers of what really happened. So rapport and trust are critical in these types of cases. I'm lucky to have seen many of the practitioners really do a great job with their clients, come in with, as Judge Fenstermacher was saying a minute ago, with factual based concerns, instead of just the blanket, oh, my client's been victimized, they've been defrauded, all their money is gone. I mean, really get to know your client and tell us about your client, because that's what sells the personality, the personal issues of your client. I'm going to shift one more gear as I continue through to my discussion, at least. And I wanted to address some common evidentiary issues that I've been seeing, again, in what I've been seeing through the trials, the bench trials that I've had over the past year and a half. But they're important. And I'm not trying to minimize these by any stretch of the imagination, but they're important. So let's say you're in trial and, you've got your witness on the stand. It doesn't really matter who it is. And you want to raise your objection. Okay, number one, this is something I would really like people to be aware of. And even the best practitioners can always bone up more on the law. Please make sure you are aware of your objection. Please make sure you make an objection and note what your objection is. You can do multiple objections. I don't have a problem with that. But please do not make a speaking objection. It's just really contrary to the purpose of your being there. So I'd like to throw that out right now. No speaking objections. And for those of us who haven't really been in court as much, a speaking objection is an objection that includes the argument of counsel. Most of the time it's in front of a jury, but it can happen in front of a court. But not only it's argumentative and it doesn't really get to the point. And sometimes it tends to take the focus off the issue that you're concerned about, and it doesn't really get to the point that you're concerned about, which is why you do not believe this should be coming in to evidence. I did some research on this, and apparently their speaking objections were the thing in the early 60s. I don't know where that came from or why, but that was something I read in one of the treatises I was reviewing in the early 60s. But we're not there anymore. We're now in 2021. So please don't make speaking objections. They're strongly disfavored because they waste time, they create bias, and they result, unfortunately, in arguments back and forth between counsel that are really unnecessary. So that's number one. Number two, a lot of you are really good at making objections based on relevance, really good. But you need to kind of know what 352, Evidence Code 352 is. So I'm happy to hear you say objection, Evidence Code 352, or objection relevance. But when you make that objection, if the court asks you, okay, can you expound upon that? Know what that statute says, because there's many parts of that statute that are actually quite helpful in a relevance objection. So the actual statute reads as follows. Evidence Code 352. The court in its discretion, so it's discretionary by the court, may, not shall, may exclude evidence if its probative value is substantially outweighed by the probability that its admission will A, necessitate undue consumption of time, or B, create substantial danger of undue prejudice, confusing the issues, or of misleading the jury. That is a very powerful tool for a trial attorney to unpack and to use when you're objecting to relevance, as a relevance issue on in your objection. Know why you're objecting. So one of the issues in that is undue consumption of time. The old saying, the old adage was, this is a trial within a trial, Judge. We can't go in on, the first 4 marriages that the elder had. It's not relevant. She's on her 5th marriage, okay, and that's relevant, and the circumstances there. But the first 4 marriage, we'd have a trial within a trial, which is undue consumption of time. Also know that undue prejudice, confusing the issues, and misleading the jury. Of course, we don't have that unless we have a jury. But confusing the issues can also apply in a bench trial, especially when you're trying to be very specific on the issues that you want the court to be judging. One other thing along those lines is I noticed when people made the objection relevance, great objection, solid evidence or solid objection, not a speaking objection, I would turn to opposing counsel and say, okay, counsel, I'm considering granting this, but what's your offer of proof? A lot of attorneys, and I don't know whether this is an age thing or being in trial or not in trial, a lot of them weren't really quite sure what an offer of proof was. So I wanted to sort of review that briefly tonight with everybody. Apologies to people who do know that, but it's such a critical component of the courts making a good and thorough decision. I thought I'd just revisit it right now. So what is an offer of proof under law? An offer of proof is a lawyer's response to opposing counsel's objection to the admissibility of evidence at trial. An offer of proof serves 2 purposes. 1, providing the proponent of the evidence the opportunity to persuade the judge not to exclude the evidence. And 2, preserving the error on the record for appellate review. And now I know that the appellate review is sort of it's kind of a moving target, right? Sometimes they get appealed, sometimes the cases go up, sometimes they don't. But, and maybe you don't know if you're going to appeal it when you're in the middle of your case. I would just suggest, and I would recommend that you prepare and you go in your trial as if it was going up on appeal. That way, no stone is left unturned. You create a solid record for you and your client. And then in the event that you do take it up or it does go up, you're protected. So always keep in mind that your record is really, it's quite important to protect the record and to make sure that whatever goes on the record, at least from your statements, is clear, it's concise, there's no question about it, and that you make sure that your record is solid. Back to the offer of proof though. How do you make an offer of proof? Well, the traditional way of making the offer of proof is the quote unquote formal offer, in which counsel offers the proposed evidence or testimony by placing the witness on the stand outside the jury's presence. Okay, we've got a court trial, you can do that with the judge, and asking him or her questions with particularity as to what the witness would testify if permitted to do so. That's allowed in all types of trials, criminal, civil, obviously probate. We're not going to have juries for a while, as I mentioned, but I'm happy to allow the person making the offer of proof the time to say, Your Honor or Judge, here's what I would like to show, and here's why. Rarely would I require a witness to be put on the witness stand to show the offer of proof, but it can be a tool. But most of the time, I'm going to turn to counsel and say, counsel, what's your offer of proof? Why should this not be not admitted because it's irrelevant? So in summation on this piece, please become familiar with offer of proof as a tool. Please become familiar with that. Know what an offer of proof is and how to present it when the judge asks you to. And I would invite you, if you're not asked and you see a judge, maybe even me, kind of quavering, going, well, I'm not sure. Make the suggestion yourself. Your Honor, I can provide the court with an offer of proof if you'd like. Sure, that'd be great. Please do so. That gives the court another option to dissect what the objection is and make a thorough and informed decision. And then finally, when you give your offer of proof, seen this happen, be prepared to provide a cogent and succinct offer and not a rambling narrative. Get to the point, make it cogent. It doesn't need to go on and on and on, but just make it cogent and succinct. That's very helpful. So thank you. A couple of other practical issues that have come up real recently in a couple of the trials has to do with hearsay. And I know some of us know it better than others. Some of us feel more comfortable than others with it, but I would invite all practitioners, especially when you're in trial, to get ready to know what that is. Know what the rule is. Memorize the rule. What is it? It's an out-of-court statement offered for the truth of the matter asserted. Back in the day when I was teaching my evidence students, I made them recite it like a mantra almost every time we met. So it just got burned into their brain. But as relevance does, hearsay has components. Out-of-court statement offered for the truth of the matter asserted. What is out of court? What is a statement? What is the truth of the matter asserted? What is that? I mean, that's really kind of the blazing issue of the day with hearsay, but don't think that it doesn't have to do with out of court or statements. So let me talk real quickly about that. Out of court, again, this came up recently. The witness on the stand, your witness on the stand, if he or she is asked, what did you say when you saw X? What did you say when you saw X? Objection, hearsay. Well, there's no hearsay because the witness is here. Well, no, that's not correct. The witness can also, the declarant can also be the witness on the witness stand because it's what the person says out of court. So you have a witness in court that makes a statement out of court. That the person making the statement out of court can still be the same person on the witness stand. So the person out of court is the declarant. the person on the stand is the witness. They can be the same person, and you can still have an objection sustained on hearsay with the same person being the declarant and witness. It's a common misconception. Note that out of court only means out of this court, out of the courtroom that you are in. So you can have the witness being a declarant in another court. And there's, of course, there's the prior reported testimony, but we won't talk about that right now. But that can be, although it's in another court, it is out of the present court. So out of Department 30, out of Department 15. Make sure you become familiar with that, because it's a common misconception. Not as common as the other one, as declarant can be a witness, but it can be there. Secondly, what's a statement? A statement is anything that is intended as a communication. Anything that is intended as a communication. It has to be, it can be nonverbal, as long as it's intended as a communication, but it must be by a person. So nonverbal communication by a person that is intended to communicate can be hearsay. So a nod or a shake of the head in response to a question, a grunt, if it's can be determined that that's a response, it's intended as communication, but it can't be, say, for example, a dog tracking a dope dog, say, for example, keying in on a locker. That's not a communication. That's not a person, much as we love our dogs. And also, it must be intended to be a substitute for verbal expression. Intended as a communication. If it's not intended as a communication, then it's not hearsay. Finally, what's truth of the matter asserted? If it's not for the truth of the matter asserted, if it's a statement, it's not hearsay. And if it's relevant, it will more than likely be admitted. But don't think that you can get around getting hearsay in by saying, well, Judge, I'm not asking that it come in for the truth of the matter asserted. Okay, then the next question, at least out of my mouth, is going to be, well, then why is it relevant if it's not for the truth of the matter asserted? And if you can be using it to show something else, knowledge, intent, something else that's not for the truth of the matter asserted, effect on the listener, then you might have it. But if you're trying to use it to get it in anyway, and it's not for the truth of the matter asserted, the court or the trier of fact, like the jury, can't consider it. So therefore, it's really not relevant. So be careful of that when you do that. A couple of final common misconceptions about evidence. This came up recently as well. Self-serving is not an objection. There is no objection saying, objection, Your Honor, self-serving. It's meaningless. And the reason why is that all evidence is self-serving. Otherwise, it wouldn't be offered. So there's no objection self-serving appearing in the evidence code at all. So it's kind of a ghost objection. It's a fake objection. Res gesti is not an exception to hearsay, by the way. I know that came and went in law school, and it doesn't exist. So please don't do that anymore. Not that you were to begin with. Okay, a couple of things. I know I'm starting to kind of get into another section here, but I want to kind of move through this real quickly. Lay opinion. Don't underestimate the power of lay opinion witness testimony. People seem to be afraid of it because they're good with experts. You guys are really good with experts. You know how to qualify, you know how to voir dire, you know how to direct examine. And I'll get to that in just a second on the expert, but don't underestimate the power of a lay witness opinion. There may be statements that are admissible that you're shying away from. So let's say the lay witness hears the elder say something. I'm sick, I'm tired, I'm dying. There's all those types of things that, you know, can lead up to this, or this is my intent on my will. This is my intent on my trust. This is who I want to have my house. This is who I don't. Some of that stuff might be hearsay. Some of it stuff might be admissible hearsay. Some of it might not be for the truth of the matter asserted. But don't underestimate the power of a lay witness, particularly a family member or someone who knows that elder extremely well, to talk about the impact or the effect or the condition of the elder, especially from observations by a person who knows that person, that elder. You can talk, the lay witness can talk about behavior, They can talk about a change in appearance, a change in grooming habits, a change in interest in life, all of which are potential components of elder abuse. Establish the foundation of familiarity between the lay opinion witness and whoever they're giving their lay opinion about. And if you have a family member or someone, for example, who knows that elder really well, you've got a pretty easy foundation to lay. So don't underestimate that. With respect, I know experts could be a whole nother discussion here, but with respect to experts, I'm just going to quickly fly through that now because I want to get to a couple of other issues. Again, from what I've seen with the folks in front of me so far, I think that that's actually a really strong point for the practitioners, for the attorneys. They prep their experts. They know what the questions are to ask. The opposing party voir dires marvelously. The one thing I would say to be careful of is when you get to the opinion that's going to give the expert, the whole reason the expert's there, really be as concise as you can. So, doctor, what is your opinion with respect to the elder's vulnerability? What is your opinion with respect to the capacity of Mrs. Smith? What is your opinion with respect to her ability to not be abused or whatever your expert is there for? Okay, here's my opinion, XYZ. Okay, and then your next question should be, thank you. And upon what factors do you base that opinion? That question, at least in my mind, as a former trial attorney, is gold. You let your expert fly on that, if that's your expert, obviously. You let your expert fly on that. And upon what factor or factors do you base that opinion, doctor? And then again, this is just a suggestion for trial prep, but you prep your witness, prep your doctor, your expert witnesses, that when you ask that question, that's really the center of why they're there, because I'm going to be writing notes all day long when I hear that question answered. I know you probably have a court reporter sometimes, but that's when a judge is really keying in on the expert. Not that they're not listening otherwise, but that's like the guts of the expert's testimony. No, okay, I'm shifting another gear. I'm trying to quickly finish what I have before Tom speaks. Know when you can and when you cannot lead a witness, okay? Leading questions are one that suggests the witness the answer, strike that. Leading question is one that suggests to the witness the answer desired by the examining party, okay? The danger of the leading question is the witness may acquiesce to a false suggestion, okay? Now, as we all know in evidence code, evidence 101, most of the time a direct exam does not allow leading questions, but there are exceptions. I'm getting to those in a second. They're always allowed on cross. Be careful on cross when you get going on those leading questions, especially if it's a witness that's it's a hostile witness. Be careful you don't antagonize the witness. Be careful you don't get too out of hand. I realize that trials can be extremely emotional and there's a lot of action going on, but try to pace yourself. Don't get argumentative when you're on cross. You'll get objections, and most of the time those will be sustained. But remember that leading questions are a good tool, and there are certain exceptions even on direct. And again, some of you guys don't know that, and you shy away when you can do this, and it really helps focus your case. So one of the biggest exceptions on direct for leading questions is to establish preliminary matters. You don't have to say, what happened in December of 2015? You can say, good afternoon, ma'am. I'm going to direct your attention to the afternoon, December 15th, 2015, at the address of XYZ. Do you recall that date? Objection leading. It's not leading. Well, it's leading, but it's allowable. So that would be overruled. But I saw that happen in a couple of trials recently, and the counsel that could have done the preliminary question just shied away and took a long time to kind of get there. We got there, but it took a little bit too long. Also, you can use leading questions to refresh the recollection of your own witness. You can use leading questions with the court's permission to assist a witness in testifying when there's an elder witness, which is obviously what we're going to have, a witness who has an illness, a witness it's not an interpreter issue, but it has difficulty in understanding the issues in front of them. For whatever reason, just ask permission of the court, maybe an offer of proof, and under Evidence Code 765, the court can allow that. So don't underestimate that tool. You may not always get it, but put it in your toolbox as a possible way to do that. Now, on the expert witness, I'm going to circle back to that person real quickly. Your witness is the expert witness. When you start asking hypotheticals, and great tool, I totally like that when people use them. It's an important and valuable tool in proving your case or in disproving the expert. But either way, when you ask the hypothetical question, guys, make sure that your hypothetical is based on evidence that has already been introduced onto the record. If you don't, you're going to get an objection to that effect. Objection, improper hypothetical. Probably get some clarification. If that's the clarification and it's not on the record, the court's likely going to sustain that objection. One way you may, and this is a good faith thing, one way you may want to get around this is, Judge, can I give an offer of proof? Yes. And I'd like to make a request of the court that I will prove this, whatever it is that I need to prove, through this witness or another witness. And if I don't, the court can motion to strike. The court will, the other party can get a motion to strike successfully or something to that effect. The court will usually allow that. Now, make sure if you ask to offer a proof, make the offer of proof, the court has the discretion to allow you to proceed with a hypothetical that has evidence that is yet to be introduced, provided that you introduce that evidence at a later time. If you don't do that, the other side's going to resurrect their objection and it's going to get sustained. The court will strike the testimony of whatever that witness testified to with respect to that line of questioning. You can lead a hostile witness on direct. You have to get court's permission, and there's, please familiarize yourself with the evidence code. That has happened a lot, especially when your witness turns on you sometimes, which happens. You can impeach a witness when they change their testimony with leading your own witness. You can impeach your own witness. And some people think, well, I can't impeach my witness. Yes, you can. If you want to impeach your witness and they've changed their testimony, provided you, again, make an offer of proof to the court or let the court know, please do so. One final piece about leading questions. When you introduce exhibits, and a lot of times we've got medical records, we've got photographs, you name it. Of course, pre-mark your exhibits as you do, and that's fine. But make your record. This gets back to what I said a minute ago. When you're making your record, don't just walk up to the witness and give them, Mrs. Smith, I'm going to show you exhibit 5. Okay, and then you just ask questions. You can do that, but if you want to make a real tight, solid record, be a little more specific. For example, Mrs. Smith, for the record, I'm going to approach you with Plaintiff's Exhibit 5. I'm going to direct your attention to that. For the record, I'm handing the exhibit to Mrs. Smith. Mrs. Smith, do you recognize this exhibit? Why, yes, I do. How do you recognize that exhibit? Well, this was a photograph of myself and my older sister just before she was diagnosed with dementia. Well, does she appear different? Okay, and then you can just go on from there, but lay the foundation, and you can lead in laying that foundation to authenticate evidence and to ask that the court admit it at a later time. Again, protect your record. You may also want to say, when you say, Your Honor, I'm going to present Exhibit 5 to the witness, approaching the witness. This has been previously provided to opposing counsel. That really makes a solid record, even though I'm sure it has. But it just shows that someone knows their way around the courtroom and can certainly create a good record, particularly if you're going to be going up on appeal. I've got a couple straggler issues that I'm probably going to have to stop with right now because of the time issue. But one final thing about opening statements. Every judge is different on whether they want you to stand or sit or whatever. I'm kind of old school. I'd like you to stand. This is just me. I think Judge Fenstermacher might not have a preference one or the other, but of course, ask the court, may I stand, or would you like me to stand? Would you like me to use the podium? Can I use the podium? That type of stuff. Most of you guys are fine with all that. But a real powerful opening statement is not a statement that just says, like reading a letter, like you're reading a letter. Do this, Your Honor. It is the plaintiff's opinion that the evidence will show the following. And that kind of circles back to what Judge Fenstermacher was speaking about a minute ago. Know your jury instructions. That's your blueprint for your opening statement if you're plaintiff, or in fact, if you're a defendant as well. But know your jury instruction, because that's your blueprint for saying to the court or to the jury, ladies and gentlemen of the jury, Your Honor, it is my belief the evidence will prove the following. And that way you give the trier of fact a roadmap, basically, of what to follow. PowerPoint is fine. We're equipped for that in D15, D30. I think D15 is too. Charts are fine. Just please make sure you show them to opposing counsel in plenty of time before you start. Let's see. I'm going to ask that there's a couple of handouts I haven't yet sent up to Ann and Samantha and Doug, but I'm going to try to get an objection handout out to you, and then as I mentioned before, the trial preference, and I will try to get a couple of other evidentiary handouts to you. But anyway, that's it for me for now. Thank you for having me here, and I'm going to go back into the non-spotlight and let Sam and Ann take over. Thank you.
Thank you, Judge George. I don't know about you, Doug, but my anxiety level for trials is now through the roof. So if you're trying to avoid going to trial, the best thing to do is to settle at your mediation. So joining us next is attorney Tom Kane. Tom is our valued colleague of practicing law and mediation for 25 years. Thank you, Tom, for joining us tonight. If I said Doug, sorry about that. Thank you, Tom, for joining us tonight. We look forward to hearing from you.
Thank you, Samantha. Thank you, Doug, for inviting me here. I'm here with my daughter, Lucille Cain, a new associate attorney with the Bray firm. I'm happy to talk to you all tonight. I'm going to adjust the computer here so I can talk to you for just a minute. I have a PowerPoint that I want to share on the screen. I know you're all zoomed out, so I'll probably go through it a little quicker and skip some of the slides. But I wanted to start about the difference. My point is the difference between preparing your case for trial and preparing your case for mediation. And so my icebreaker question to you all is, it seems to me that attorneys come to me, and I work for the attorneys. They hire me to come and try to help settle the case. They seem to think that if they are preparing their case for trial, that's sufficient preparation to go to mediation. So that's my question to you. Is that how you prepare for mediation? And what's the downfall of that? And what are the problems with that? And I want to talk about that. So the main takeaway tonight before I get to PowerPoint is, no, that is not a good preparation for mediation. Makes it much more difficult to settle. And I'd like to talk a little bit about why that is. So I'm a litigator as well, and I know that we want to win. And that's everything we learn in law school, is to prepare ourselves for that 1% of the cases that actually go to trial. It's around 1%. So everything that we do is geared towards that, and we want to win and get across the finish line. And I was reminded of this recently by a retired judge, John Sugiyama, who said, really, it's a whole different type of persuasion in a mediation. He works for JAMS now, and it's something I've been aware of as well, that it's not based upon what Judge George and Judge Fenstermacher were talking about, the admissibility of evidence. It's a whole different type of persuasion. It's a different exercise. So you spend your treasure to get to that 1%, but actually when you mediate, you're now wearing two hats. Your first hat is as the thoroughbred horse that wants to win, the advocate. And and you take on that persona. That's your professional persona, and we're proud of it, and we've told our clients that we've got a good case and those sorts of things. But then we have the other hat. The other hat is our role during the mediation, and there's a conflict in these two roles, and it's a critical conflict. It's really a problem, and I see it all the time. The attorneys have told their clients, we're going to win, we can beat these guys. When we get to mediation, it's a different type of process, and it's objectively our case. Suddenly you're faced during the mediation of telling your client something they've never heard before. Objectively, our case has strengths and weaknesses. We can settle with these guys. So it's a different focus, and it's sort of embarrassing, I think, to attorneys to have to go back to their clients and say, yeah, there could be some problems with some of our witnesses, and they're vague about it, and they haven't prepared their witnesses. And this obviously applies to me too, because I hire mediators when I'm in litigation. Let me go to the screen share function and jump into these PowerPoints. So naturally, it's not working. So there's the question. Is preparing your case for trial sufficient preparation to go to mediation? The answer being no. I'd like to just briefly remind you what we do in mediation and how mediators look at it. The first part of it is contracting, and I don't mean just getting hired. It's getting buy-in for what that process entails, and there should be much more time spent with the attorneys and their parties understanding what that process is, and that they're going to come in and try to work through and come up with a settlement. The second stage of mediation is the storytelling, and the parties tell their stories, the mediator listens, and in theory, and this is the important part, the other side is listening. Now, many times in elder abuse, and that's our focus here, it's not just a plaintiff and defendant, and it becomes much more complicated, and that's where the attorneys can help the mediator structure it and work up a formula, or multiple rooms, or multiple Zoom rooms, however you want to do it, to have parties understand their role in storytelling, and get things off their chest if that's what they want to do. The third stage in all mediation is what we call working the problem. That's where you really go deep, and you can take issues and the problem, and out of them break them down and explore the problem and try to understand them better, generate options out of it as to each issue, improve your perspective, understand the needs and values. Some people want to jump directly to brainstorming towards solutions or getting to settlement offers. Many times these stages you have to go back and work on contracting or storytelling or digging deeper, because that work has been ignored and the parties haven't listened to each other. They're negotiating in a vacuum, and it becomes very, very difficult positional bargaining that ends up with the parties very angry and upset because they have no idea what happened and how they got there. Of course, the fifth stage is getting to the shared text of a settlement agreement, getting signatures, and testing it out, making sure that the agreement is doable, that it's workable. That's particularly important in conservatorships and elder abuse cases, 90% of which involve many family members. So the additional stages in mediation involving elder abuse, and especially conservatorships, are to get buy-in from the many stakeholders. This could be family, they could be friends, they could be professional or less than professional care providers, trustees, conservators, guardians ad litem, and they need to be prepared and to understand their role in the mediation process. Now, many of the attorneys that I've worked for in this county, they get it. They come to me with very carefully prepared briefs, and they'll lay out for me who the primary stakeholders are, who the secondary people are, and we have good conversations in advance to find out who's essential, who maybe should be excused, and so forth. Something else that comes up in mediation a lot is determine if the elder has sufficient capacity to participate in the mediation. And it's the same type of determination, but often the guardian ad litem, and I get a variety of opinions from the attorneys, will help me come through that. But just because somebody has capacity issues, we're talking about their life, we're talking about their money, we're talking about where they live. It just doesn't feel right not to include them if there's any way that we can include them. You know that that can make it difficult, but that's what we do. So we also consider who else could participate, a clergy member, a friend. The additional stages also include accounting issues and having a budget for elders' care. Very, very essential. And not in all cases do I find that. People just give me, a brief and then about 400 pages of pleadings, and I guess I'm supposed to be paid to review them like a judge, which is fine, but it's not the most efficient way of understanding what we really want to tackle during the course of a mediation. Sometimes you understand under the elder abuse statute and so forth, you can get punitive damages, and people will come to me and spend a lot of time talking about getting punitive damages. Not in mediation. If you want to win punitive damages, go to court. Now, I put an asterisk next to that because sometimes there really is a smoking gun. And I don't mean a presumption or an inference. I mean a smoking gun. There's something that is just so abusive and it's documented that, and usually both attorneys will come and say, we need to settle it because this is bad and there's evidence of it. But most of the time when people talk about punitive damages, I think they're trying to impress somebody, but it can't be me. I guarantee that. I just have to shut that down because I'm not allowed to do that, and the other side is simply not going to respond to it in mediation. So what it means is that you're not in trial, and you have to be prepared to be an effective advocate during a different process in mediation, where many of the times people want to settle, but they're not paying attention to the evidence. They don't have to pay attention to the evidence. They don't have to give credence to witnesses who will testify at trial. And so it becomes a different process. Finally, do everybody a favor. Don't go into the mediation saying, well, we didn't come here to pay any money. We're not doing that, because that just sets everybody back by saying, okay, why did you come to mediation? So be prepared, be focused on the process of what mediation is. There are cases where people settle out without paying money. I'm not saying that, but most of the time, somebody's exaggerating and bullying and blustering. What mediators want is to work with attorneys and clients who are trustworthy and will trust them, because that's the stock in trade. Mediators don't have any power. They can't do that. So we have to build trust and confidence that we're working towards something good. Not many of the attorneys I work with flat out lie, although there's some puffing in the numbers and that sort of thing that I have to live with, but there's a lot of exaggeration. It's the first cousin of a lie, one-sidedness, slandering the other attorney is unprofessional. We are officers of the court. There are professional ethics that we don't shed the moment we walk out of the courtroom. And it makes it hard. It's a confidential process, and everybody knows that, but it really doesn't help. I don't know who it's meant to impress. So be on good behavior. In terms of diminished capacity, the rules of professional conduct, remember, the first phase of mediation is determining somebody's capacity. You might want to take it, Rule of Professional Conduct 1.14. What about your client? So if the client's capacity is diminished, the lawyer shall, as far as reasonably possible, maintain a normal client-lawyer relationship with the client. B is where it gets more severe, where the lawyer reasonably believes that the client has diminished capacity or is at risk of substantial physical or other harm and cannot adequately act in the client's own interest. The lawyer may take reasonably necessary protective action, consult with individuals and entities that have the ability to take action, and in appropriate cases, seek the appointment of a guardian ad litem, conservator, or guardian. I find many of the attorneys in the counties are very good at this. The bench officers follow this, but it's something to pay attention to because the lawyer representing that person has a duty to do it as well. So there's a lot about capacity. Now, the capacity test that I use most often is I'm walking down the street in Martinez after a long, hard day or too many Zoom hours, and I run across Judge George or Judge Fenstermacher. My capacity test looks like this. Hey, Judge, how are you? Pretty good. Been a long, hard day. Yeah, me too. It was good to see you in court last week. Thank you very much. I hope that case turned out well. Hey, what are you doing this weekend? Oh, I'm not watching Zoom. There's a give and a take and a call and a response with appropriate responses that are very, very important in determining capacity. It's not a good test in terms of the law, but you will know just through that kind of back and forth that people can track, listen, and make appropriate responses. Judge Fenstermacher talked about the statute that's here. You really do need to have the facts and the chronology and the law. And be prepared not to win, but to settle. I have to tell people all the time, did you come to win or did you come to settle? If you came to win, you're going to need to go back to court. If you came to settle, that means you're going to get less than the amount that you hope to win at court. Sometimes in elder abuse cases, you're talking about a family history, 10, 20, 30 years. The clients live through it, and they just live in that world. The attorneys skeletonize it down a little bit and to the key facts, that the trust was made in 2017, but that the elder had some dementia behavior, diminished behavior or issues back in 2016 and so forth. I need to know that. That's important to me. If you have medical records that show, concern about forgetfulness and some other issues, I need to know about that. The most damaging and important evidence that I want to know about is a massive change in the elder's behavior. Used to like following the A's, used to watch daytime TV, took the Jaguar out of the garage and washed it in the driveway every weekend. Suddenly, none of those behaviors are happening. Suddenly, the spouse or somebody else sold the Jaguar. Something's going on. And those are the types of things that are very, very important to track when somebody's being subject to undue influence. So you want to bring in objective information. It doesn't have to be admissible during a mediation, but it has to be objective, and you need to share it in advance. I can't tell you how many times I'm in a mediation and the attorney says, we've got some really good documents. I didn't bring them today. And they'll say, hey, Tom, could you vouch for my documents if I have somebody in my office send them to you? And I say, no, I can't vouch. The other side barely knows me. The parties have never seen me before. And I'm not going to vouch for your documents. Have somebody scan them and send them to the other side. Mediation is the place to share the documents. It's confidential. So share it in advance and be ready. If there's income and expenses, don't bury it in accounting. Put it in a spreadsheet and let's get right to it. If there are valuation issues of a residence, be prepared. Talk to quality realtors that are objective. Just share their opinions. That's okay. If somebody's coming in with, I thought I saw a stock portfolio statement in 2014, don't want to hear about it. You need objective information. I mean, imagine if you're like my wife, who's an enrolled agent and tax preparer. You're doing a tax return for somebody. They come in to meet you and they say, I've got $40,000 in credits and deductions. And the tax preparer says, great, let's see it. Certainly you have some documentation for that. And they say, well, no, I don't. I can't find it, but just put it in my return. IRS isn't going to buy it. Tax preparer isn't going to buy it. And it doesn't work in mediation. So come in with objective stuff that we can work with and share and look at together. That creates confidence and trust that we're looking at things that really do matter in the persuasion of settlement. So have a plan, know what you want. And many people don't do this because they're thinking about trial. They haven't really thought about what they're going to do in mediation. So be realistic about the money. If it involves care for an elder, who really is the adult in the room? who can carry it out? Are there a couple of people on each side that are less emotional, more businesslike, that they could be the point people for communicating when problems come up again? I've seen a number of attorneys in this county, and my hat's off to you. They're really very, very good at that, but there is room for improvement on these points. So finally, just be flexible. Sometimes people, and this is true for professional fiduciaries, they want the Mercedes-Benz version of care for the elder. Well, a lot of people can't afford that. It'll bankrupt the estate. And maybe they need, the Buick or the Ford Fiesta even. Just depends on, the family and their circumstances. And you have to be practical and flexible. I'll just move on because we're all getting zoomed out. This should go without saying, but I'm going to say it anyway. You do need to give ground. And if you haven't prepared your client, if you're just telling your client the other side's greedy and they only want money, then I have to say, well, it's funny, they said that in the other room. So you need to be prepared to give ground and to discuss the strengths and the weaknesses. I think many attorneys have been posturing with their clients, and they love talking about how good it, what they're doing and how good it is, that it's almost embarrassing to suddenly show up at a mediation and have to admit that there are strengths and weaknesses, that things might not go as well at trial as you think. Don't wait for the mediation. Be frank with them and tell them, this is confidential and this is true in all cases. So what is the risk of going to trial? Quantify it. You got a 60-40 case, 70-30, whatever it is, quantify it. Show why that matters. If it's $100,000 that's in dispute and you've got a 50-50, with an equal chance of winning or losing, settlement value is $50,000. You can do the math. What does it cost to go to trial? You need to quantify that. When will you get to trial? You heard what the judges said a few minutes ago. Maybe this year, maybe next year. When will you get to jury trial? Maybe eventually. You need to be real about those things, and the cost to the client and the wear and tear is what it's all about. This is something I can't spend time on because I'm past my time, but I really wish we had special classes before you could get licensed as an attorney to sharpen your listening skills. Listening is the most underrated quality in life. If you find someone who listens well, you should marry that person. So sadly, and this includes me attorneys not often are that skilled in listening, only in talking. Listening is different. You have to sort of empty yourself and allow it just to go in. Doesn't mean that you agree with it. It just means that you're paying attention and grasping what the other side is trying to say. There's a lot of stress in law and in litigation, and there's a huge amount of stress in mediation. People think, I'm going to get away from the conflict. I'm going to get away from the stress. Tom, let's mediate with you. You're not getting away from the conflict. You're bringing it into my conference room. So if the other side is talking and you're preparing your rebuttal, thinking about what you're going to have for lunch or what time it is, you are not listening. And if you won't listen, should the other side listen to you? I struggle with this every time I mediate. And I struggle with it, in my personal life, my family life. We're not really very good at listening, and that's where we need to grow. The goal is dialogue, not monologue. Monologue is a person who's concerned only with their own point of view or their self. It's very exploitive. It's what I want. If you hear somebody say, I've told them 100 times, it means you're not communicating. They're not hearing you. You're not listening to them and they're not hearing you. It's not a dialogue. So I'm going to move on more quickly, but these are the things that mediators, probably judges as well, look for in attorneys and professionals coming before them, that they'll be able to engage in a dialogue and listen. Sometimes parties don't want to settle. I won't spend much time on this. They want free discovery, learning about the other side, testing the other side, using it for their trial prep, finding the strengths or weaknesses. These things are okay, and I think everybody does it. But if you're not there really to try to settle it, I'm wondering whether it's mediation in good faith. But that's another story. And you can say, yeah, I was referred out by the judge. But the mediator is going to want to know that. Why are you there? Finally, in conservatorships and these things is the team approach. since 90% of elder abuse involves bad conduct of family member, let's not just badmouth family members. The family members are often the person who's going to take care of the elder. And the thing that is the most lovely and good report is when I have attorneys come to me and work with the other attorneys for the good of the people that are in their care, for the family, for the people involved in it. And yeah, sure, one of the adult children is living in the house and may not be doing their share. That doesn't matter. That's just life. So it's the most refreshing thing when people come in realistic about who we are and our strengths and faults and all that, and they come up with a plan that allows this elder to have contact with the family, and we draw everybody onto the team. If the elder is a woman named, Doris Smith, we become the Doris Smith team. That's the best of all outcomes. I have a practice problem here, but I'm going to skip it because you're all beyond this. And that pretty much wraps up my presentation for tonight. I'm going to end screen share and turn it back to you all. Thank you.
Well, thank you very much to all three speakers. I think this has been a huge success. And if you were unaware of how to prepare for trial or mediation, you better be ready now, because there has been a monumental amount of information provided. If nothing else, learn the evidence code. And importantly, if mediation, open your ears and prepare your clients accordingly to understand that settlement is dirty. You don't get what you want, and that's the whole idea. So once again, I want to just thank the presenters. We recognize that you guys are obviously busy, and so this is, so we got some questions and whatnot. We got a poll that Ann is doing, so we'll let the poll, I suppose, go first. Is that correct, Ann?
They can do the poll and we can do questions all at the same time. I just put it up there for people.
Perfect. And I want the attendees to understand a few things with regards to the questions. Some of the questions can be answered now, but some of them, in all likelihood, will be responded at a later date, because guess what? No answer can be simple. And many times it requires an in-depth analysis, maybe some research, et cetera, et cetera. So Virginia George and Susanne Fenstermacher have agreed, at least in theory, to take some time out of their busy schedules to respond to some of the questions that are more in depth. So if we don't ask those specific questions, we are not purposely ignoring you. We're just giving you the heads up now. Samantha, would you like to ask the first couple questions, and I will open my ears and listen and stay pretty?
Yes, actually, Doug, the questions that we have for the judges are pretty involved, and those are the only questions that we have right now in the Q&A. I have already typed those out, and I'm prepared to submit them to the judges at a later date. If anyone has any questions for Tom Kane, please go ahead and put those in the Q&A. In the meantime, I believe that Ann has sent out a poll.
Well, I have a question for Tom Kane, because I am actually, as the panelists know, I'm still in mediation currently on a separate matter. We are 9 hours into it and no end in sight. But is from a standpoint in kind of coming to a mediation with, open eyes and reasonableness. I know that there are counsel, there are parties who want to do a private, confidential mediation kind of brief. And if you could kind of enlighten me, at least, on the pros and cons, if any, of that approach. And I mean, part of me is like, well, that already gives a kind of a sour taste in my mouth. Like we're going to this safe area, this mediation, with the understanding that we're gonna, express how we feel and hopefully come to a settlement. And when I hear that, opposing side or whatever is doing a confidential mediation brief, I'm already kind of, off.
That's a really good question, and it's something that I struggle with a lot. I I don't frankly understand it, Doug, because that's what the evidence code provides, and that's what the confidentiality agreement provides, and it's what I was talking about earlier. If you have something of import, objective data to back up some of the statements, share it. Share it, because what I have to do when I'm saying confidential for the mediator only, and then I call the attorney on the phone saying, why? What do you want me to do with this? I will understand it, but I'm not the person that you're persuading. Your audience is the other side. Would you please share it? And sometimes they'll say, well, I'm not sharing my brief until they share their brief. And then I'll get on the phone and call the other side and say, we really do need to share this information because I'm okay. I'm reasonably intelligent. I'm a good communicator. I love people, all that stuff. But I'm not going to be able to recreate the impact of your, you put probably $5,000 in this brief. They need to see this. This is impressive stuff. Why don't you share it? That's why we're here. So you have to appeal to the mediator to do that. You can appeal to the other side. But some people, this is a surprise, Doug, some people are control freaks, right? They just, I know, it's hard to believe. They just won't let it out of their control.
So on that same kind of like, I know Judge George has mentioned it in hearings and stuff like, hey, you guys are going to mediation, maybe, if it's a discovery dispute or whatever, maybe you guys can agree to, a confidential kind of mediation, understanding so that you can disclose this information to kind of make progress. And I have personally done that. I think it is successful, but I have experienced situations where they say, well, this is our ace up the sleeve, so to speak, or whatever, and we don't want to disclose it. And then they're going to just ask for it afterwards and discover if we don't kind of settle in mediation.
You're right about that. And Mike Buselink in a private chat to me pointed out there are some things that do have to be kept confidential. The weakness of your case, the problems, things that they anticipate, that should remain confidential between you and the mediator. Just let the mediator know. But to have your whole brief and all your documents be confidential, the mediator's there to try to communicate and is going to test you. Why don't you share it? Isn't this a place for it? Sometimes they allow it, and sometimes they just want to hold it because they're not ready for the discovery that will follow.
All right, I got one last question just because I'm infinitely curious. Now, I know that I've been in situations where people go to mediation very early on in the case, right? Before the discovery battles, et cetera. And I think it's in theory a good idea in the sense of like, maybe we can get ahead of this. Maybe we can knock out some of the minor issues so that when we actually go to court, we're dealing with kind of the legitimate concerns that we just disagree with. And then many times I've also experienced it just being unsuccessful in mediation early on because the natural organic kind of life of a lawsuit has not fully taken place to get to the point where the clients are sweating or concerned or whatever it might be. Is there any suggestions or recommendations that you can say with regards to timelines of mediations, in the life of a lawsuit? Is it like your preference to do it after discovery or what?
It's a really good question, and it's a case-by-case thing. I mean, part of it, as you know, depends on the amount in controversy. If the parties are really, it's a $5 million estate, but they're only disagreeing about $100,000, you need to get into mediation because you're going to eat that up in a matter of months. And it depends on who the other attorney is, but it can be premature. People get there and they saying, well, I haven't seen any of those documents. I can't do that. What mediators do is they'll say, we're only 2 hours into this. I'd like to come back to mediation after you've done this part of discovery. You can actually come up with a discovery plan and then come back in a couple of months for day 2 or another half day. That's a good way to go. I always admire attorneys that aren't just lining their pockets. Gee, we're gonna mediate a week before trial. Give me a break. You got $200,000 in attorney's fees. How are you going to get that back? And so I admire the effort to mediate early. It's not always successful, Depends a little bit what the issues are and who's on the other side.
Yeah, sometimes during those early mediations, I'll use that as a place to kind of do informal discovery if I don't have anything to hide. And it's just, you want to see the documents and it's early on to get to settlement. I've used it as an opportunity to exchange information informally that way.
Yeah. Why not? They're going to get it anyway. You know, exchange information. Do everybody a favor. Give them the information. It's all discoverable.
Yeah.
Judge George, would
Okay.
you like a softball question just so that you can answer something, or are you sufficient with the very complex and detailed questions that have been posed by the attendees?
I'm okay to just answer the complex questions at this time.
That's fair, because I was going to ask, like, who is your, favorite redheaded bearded attorney? But we can just, we can worry about that another day.
There's just so many.
Objection, relevance.
Can I have an
Well
offer of
played.
proof? May I please have an offer of proof, Mr. Hausman?
I got nothing.
And on that lovely note, thank you again for having me. I'm going to go and see what's available for dinner tonight. So thank you. Nice to see everybody.